Good morning. To understand labor law, you must read Factories Act. Factories Act is the oldest act which was enacted for the purpose of welfare of the employees. So basic requirement for Factories Act that it should indulge in manufacturing process, number one. Number two, there should be employees more than 8 persons. I think I am correct. I will go through and again come to you. There were, they say, factory means any including precinct itself, where 10 or more workers, 10 or more workers working on a day, and other things are there regarding other process. So in that Factories Act itself have some restrictions like maternity leave, not allowing the pregnant woman dealing with hazardous substances, so many things which was subsequently like Contract Act, several other acts were thereafter, formation of union, then Industrial Dispute Act, Standard Act, whatnot, lot of things. Suppose, for your information, suppose if that process of a company does not having more than 10 members, then question arises shops and establishment. Then again Shops and Establishment Act is there, compulsory declaration of holidays, and then Minimum Wages Act, so many things are there. Therefore, to understand the entire concept and implementation of labor laws, you must thorough with the Factories Act. So today I am going to discuss with a judgment about Factories Act, number one. Number two, about the lawyer who made an attempt to interpret the law. Then the Supreme Court judgment regarding interpretation as well as how to interpret when there is two acts conflicting for one subject. All these things you have to understand it. So now I will require you to go through the judgment AR 2025 Supreme Court 1374. AR 2025 Supreme Court 1374, State of Goa and another, and versus Namta Tripathi. Namta Tripathi was running a premises where she was dealing with dry cleaning business, dry laundry business. So the inspector of factories went there and saw more than 10 persons were working. Therefore, he charged him for running a factory without valid license. So charge sheet was filed, complaint was filed, because this complaint is a complaint by public servant under 190B CRPC. Summons were issued, lower court has held, prima facie is made out. Then the said owner of the company went to High Court. High Court had categorically discussed and quashed it. The discussion of the ground raised by the defense counsel is highly appreciating, though he could not succeed. At paragraph 10, they say, whenever any washing or cleaning is done of any article or substance with a view to use that of use such a way that a new marketable commodity would come into being known commercially for being used as such a selling or for selling the same and so on, then the process would certainly come within the definition of manufacturing process. So mere labor bestowed on an article, even if the labor is applied to machinery, will not make it manufacturing. On that score, High Court on that score as well as a non-application of mind quashed the complaint. But the Supreme Court has held in a different way. They say washing or cleaning of any article is covered by phrase manufacturing process. So they have stated that the laundry of business is being brought under the definition of manufacturing process, therefore causing the complaint by the High Court was set aside and retrial. Trial was directed to be prosecuted, to be go on. Then the question arises: the Act, Factories Act 1948, was brought with the object of bringing the manufacturing process, laundry, by when that was not available in Act 1934 of the Factories Act. So that the one thing is that. Then the question arises: Mitchell rule of interpretation. So the interpretation which is not benefit for the legislation, intention of legislation as well as the society and the object of the act, that is called a Mitchell rule of interpretation. But one thing is there, that unless and until court permits to argue Mitchell rule of interpretations, there may not be golden rule of interpretation. First, allow them to argue. They have argued and succeeded before the High Court also. But however, Supreme Court set aside. Then the question arises: they have used a word, jettison. They have used a word, jettison. So jettison means a reduction of the value. At that is at paragraph 42. Then they say, when there is interpretation of statutory interpretation in definition in another statute, where the statute under consideration itself defines the purpose of the act in a certain phrase, court of law is bound to apply the term defined except in exceptional cases where opening part of definition, anything repugnant in the subject or context applies. So that area you should also read, because here the case referred to Supreme Court dealt under Factories Act 1948 as well as Central Excise Act 1944. So kindly go through this and try to understand. And the object of Factories Act were discussed. So I again request you to go through the Factories Act, the concept of Factories Act, the several provisions, beneficial provisions in the Act have been separately implemented, like Maternity Leave Act and bonus payment of Minimum Wages Act, Industrial Dispute Act, Trade Union Act, what not. Okay, best wishes.